Hello from Michigan Alliance for Families. Thank you for joining me today for this video about due process complaint and hearing. Michigan Alliance for Families provides information, support, and education for families of children and young adults birth to age 26 who receive or may be eligible to receive special education services. Before we get started, I'd like to review some acronyms, symbols, and abbreviations that you will see throughout the video. ALJ is Administrative Law Judge, CFR is Code of Federal Regulations, FAPE is Free Appropriate Public Education, IDEA is Individuals with Disabilities Education Act, IEP is the Individualized Education Program, ISD is the Intermediate School District. This is also called an Educational Service Agency or a Regional Educational Service Agency. LEA is Local Educational Agency. This is a school district or a charter school. MDEOS is Michigan Department of Education, Office of Special Education. MDR is a Manifestation Determination Review. MOAHR is Michigan Office of Administrative Hearings and Rules. MARS is Michigan Administrative Rules for Special Education. And as defined in MARS, parent means a biological or adoptive parent, a foster parent, a guardian, and this could be a grandparent, a step-parent, or other relative with whom the child lives and who's authorized to make general or educational decisions, a surrogate parent who's been appointed in accordance with MARS, a person identified by a judge's order, and a student when he or she reaches the age of 18 if a legal guardian has not been appointed. Public agency is a state educational agency, a local educational agency, an ISD, a nonprofit public charter school, and any other state agency providing education to students with disabilities. If you see an R next to a rule, that means it's a Michigan Administrative Rule for Special Education. And if you see the double S, that means it's a section of the IDEA. I'm going to discuss federal regulations and state rules for due process complaints and hearings, as well as dispute resolution options available to both parties involved in a due process complaint. I'm going to talk about the process, procedures, and timelines for the standard and expedited due process complaint and hearing, and how to file an appeal for a final decision and order. Guidance documents and resources are included at the end of the video. The Individuals with Disabilities Education Act, the IDEA, is the federal law governing special education. Congress reauthorized the IDEA in 2004 and most recently amended the IDEA through the Public Act 114-95 Every Student Succeeds Act in December 2015. Michigan Administrative Rules for Special Education covers how federal laws are implemented in Michigan. The IDEA sets the minimum requirements. States can do more but not less. For example, federal law includes eligible students with disabilities 3 to 21 years old. Michigan rules allow for special education programs and services to eligible students with disabilities from birth to 3 years old and extends the age for eligible students without a diploma from 21 to 26 years old. The Individuals with Disabilities Education Act and Michigan Administrative Rules for Special Education are the foundations for special education. The sections of the IDEA and MARS noted here are related to due process complaints and hearings. In April 2020, Michigan Department of Education released the Special Education Due Process Complaint Procedures document that provides information for parents about the complaint and hearing process. And this document is in the resource section at the end of the video. There are many dispute resolution options available to address disagreements between parents and schools regarding the education of children with disabilities. I always want to talk about informal ways to resolve disagreements before discussing processes that are more adversarial. I'm going to discuss informal meetings, reviewing and revising the IEP, meeting facilitation, mediation, state complaints, and the remainder of the presentation will focus on due process complaint and hearing procedures. IDEA and MARS encourage informal resolution of disagreements between parents and school teams. The most effective options involve early and meaningful communication in a collaborative manner. If you have a disagreement or issue of concern regarding your child's education, you are encouraged to reach out to the teacher, principal, or special education administrator as soon as possible. Informal meetings allow parents and schools to work together, preserve relationships, and avoid costly hearings. This option also allows decisions to be reached faster without intervention from a third party. Informal meetings can be used to discuss any topic and are not limited to special education issues. Anyone can be involved in an informal meeting who may be helpful in getting the issue resolved. For example, the principal, a special education teacher, an administrator, a general education teacher, or private service provider. A meeting can be held specifically to review or revise the child's IEP and make changes as an IEP team. All relevant members of the IEP team should be present for this meeting. For example, if you're specifically addressing speech and language goals for the child, the speech and language therapist should attend the meeting. If you are discussing an increase in social work services, the speech and language therapist may not need to attend this meeting. When disagreements cannot be resolved through informal discussions with the school team, there are other options available, including facilitated meetings, mediation, state complaints, and due process complaints. Meeting facilitation can be used as soon as a meeting is scheduled. A neutral trained facilitator can help promote effective communication, keep the discussion focused on the issues at hand, and ensure the conversation allows all to share their thoughts and ideas. Any special education meeting, such as an IEP meeting, manifestation determination review, or a meeting to develop a behavior plan, can be facilitated. This process is voluntary. Both parent and school must agree to participate. There's no cost to the parent or school to use a meeting facilitator. Facilitation can be used when relationships are strained or participants are feeling uneasy about a meeting and would like a neutral third party to help steer the conversation. The meeting facilitator will develop an agenda based on input from the parent and school, stay neutral, facilitate the meeting process if asked to, and keep the discussion focused on the specific issue to help work through the points of disagreement. The facilitator also makes sure that everyone follows the ground rules set forth at the beginning of the meeting and keep track of the time. A facilitator is not part of the team, does not give legal advice, make decisions, or advocate for a particular position relating to the issues being addressed. Mediation offers a safe, neutral environment for parties who disagree in order to resolve a specific dispute. Mediation does not delay a parent's right to file a state complaint or due process complaint. It's a voluntary process. Both parties must agree to mediation. A trained neutral mediator guides parties through the mediation process, assisting in negotiation to resolve differences. Conversations are confidential and can't be used in other court proceedings, and the agreement is a legally enforceable document. There's no cost to the parent or school district to participate in mediation. Mediation can be used for any dispute, such as eligibility for programs and services, amount of special education services, transition issues, placement, communication, or relationship issues. Mediation can be used at any time before the hearing without stopping the complaint investigation timeline. A mediator will stay neutral and help parties agree to the ground rules for the meeting. The mediator will explain their role, ensure all parties know that the conversation in the mediation is confidential, conduct the mediation, and ensure all parties have a chance to voice their thought and concerns. The mediator will take notes during the meeting, help the parties remain on topic of the disagreement they are mediating, and assist parties to work through their conversations to guide them towards creating an agreement. If an agreement is reached, the mediator will record the agreement. The mediator will not make decisions, will not give legal advice, or take sides during the process. A state complaint is a written signed statement that alleges a public agency violated state or federal special education rules or regulations related to special education programs and services, an intermediate school district plan, the Michigan Revised School Code as related to special education, a decision made by an administrative law judge, or a state application for federal funds. State complaints can be filed for a variety of reasons. Some examples of issues that can be addressed through a state complaint are a parent not being invited to an IEP meeting, an IEP not being implemented, the district not responding to the parent's written request to evaluate, or the evaluation was not completed within the timeline required, programs and services are not appropriate for the student, or the district didn't allow the parent to see the child's records. A state complaint must be filed within 1 year of when the alleged violation occurred and can be filed by anyone. It does not have to be filed by a parent, and it can be filed by an organization on behalf of a student or a group of students. Parents or schools can request a meeting facilitator or mediator through Special Education Mediation Services, SEMS, which provides services at no cost to parents or schools. SEMS is an Individuals with Disabilities Education Act grant-funded initiative that uses trained mediators and facilitators who are not employees of the Michigan Department of Education, an intermediate school district, or school district. The IDEA mandates that procedures are in place to allow parties to resolve disagreements through a mediation process. Parties can contact SEMS by phone or fill out a request for services form online. SEMS will gather the needed information about the child, school, and the issues at hand, and will provide information about how their services may help the situation. SEMS contacts the other party for agreement to participate and will coordinate with the local dispute resolution center to arrange a mutually agreeable date, time, and location to meet. SEMS processes all the necessary paperwork, and the parties meet together to work to try to resolve the issue. You may decide to file a due process complaint if you've tried to resolve the issue of disagreement through informal processes, maybe even filed a state complaint, but the issue is still not resolved. A due process complaint is initiated by a parent or public agency alleging that the other party made an improper decision for a student with a disability regarding identification, evaluation, educational placement, the provision of FAPE, or an appeal to a district's manifestation determination review decision. On behalf of a student, only the parent or parent's attorney can initiate a due process complaint. If a student is over 18, the student must initiate the complaint unless the parent is a guardian. Power of attorney does not allow a parent to initiate a complaint on behalf of a student 18 years or older. Just a reminder that parent as defined in the IDEA means a parent, a foster parent, a guardian, a person acting as a parent of a child, or an appointed surrogate parent. Public agency is an agency responsible for providing education to students with disabilities. Some examples are an intermediate school district and a nonprofit public charter school. Most due process complaints are filed by a parent. An example of a situation in which a district may initiate a due process complaint is when the district refuses to initiate a parent's request for an evaluation. The district files the complaint to request a hearing to show that their evaluation is appropriate. Due process complaints are not for matters about individual school staff. Those are addressed by the local school district. Parents should go up the chain of command in the school district to resolve these issues. Issues of discrimination or access to education under Section 504 of the Rehabilitation Act of 1973. These complaints are overseen by the Office of Civil Rights. Matters about student records can be addressed to the Student Privacy Office, U.S. Department of Education, and information about confidentiality and access to student records can be found in the Family Education and Privacy Rights Act, FERPA. Allegations of abuse and neglect are overseen by the local law enforcement agency and/or Child Protective Services. Now that you know what a due process complaint can be filed for, I'm going to talk about what is required when completing the due process complaint itself. The Michigan Department of Education has a model due process complaint form. You don't have to use the model form, but whether you choose to use the model form or write the complaint out on your own, be sure to include all of the required information or your complaint will not go any further in the process. The minimum information that must be in the complaint includes the student's name, the address of the residence of the student, the name of the school the student is attending, in the case of a homeless student or youth, available contact information for the student and the name of the school the student is attending, a description of the nature of the problem, a proposed resolution, this is what you as a parent feel is an appropriate resolution to the issue, and the signature of the person filing the complaint. Make sure your description of the problem is clear. It must be clear enough for the other party to understand the issue and respond to the allegations. Due process complaints can be delivered by hand, mail, emailed, or faxed. Send or deliver the due process complaint to Michigan Department of Education, Office of Special Education, 608 West Allegan Street, Lansing, Michigan, 48909. Be sure to include Office of Special Education in the address. You can also fax the complaint to area code 517-241-7141 or email it to mde-ose@michigan.gov. The complaint is considered received on the day it is received by the Michigan Department of Education, Office of Special Education, excluding weekends, federal and state holidays, and days the Michigan Department of Education is closed. Complaints received by email or fax are considered received when the last page is received. If it's received after 5 p.m., it will be considered received the next day the Michigan Department of Education is open. A due process complaint must be filed within 2 years of the date when the party knew or should have known of the problem. There are some exceptions if the complaint could not be filed within the timeline because the school district specifically misrepresented that it had resolved the issues identified in the complaint, or the school district withheld information that it was required to provide to you under the IDEA. Due process complaint timelines begin the day the complaint is considered received by the Michigan Department of Education, Office of Special Education. The party not filing the complaint has to respond within 10 calendar days of receiving the complaint with a response that addresses the issues in the complaint. The attorney for the district handles the response to the complaint for the school district. If information is missing in the complaint that is filed with the MDEOS, the parent or parent's attorney will be contacted and given the opportunity to provide the information. If the information is not received in a reasonable time, MDEOS will forward the complaint on to the Michigan Office of Administrative Hearings and Rules without the information. MDE provides a copy of the complaint to the parent, school district, and intermediate school district by mail or electronically. MDE forwards the complaint to the Michigan Office of Administrative Hearings and Rules. The complaint is reviewed by an administrative law judge who determines if the complaint is sufficient and properly filed. This means that all the required information is included and the administrative law judge has authority over the issue. If the complaint is sufficient and properly filed, the process moves to the next steps, which include the resolution meeting, mediation, and if appropriate, a pre-conference hearing. An administrative law judge can dismiss a due process complaint if there's no authority to hear the case. For example, the complaint is not related to identification, evaluation, educational placement of a student with a disability, the provision of FAPE to a student with a disability, or an appeal of a district's manifestation determination review decision. The ALJ can dismiss the complaint if the violation occurred more than 2 years ago or if the person who initiated the complaint does not have the standing as a parent or guardian. The ALJ can also dismiss the complaint for reasons of sufficiency. For example, the complaint does not have the minimal information required, allegations are not specific, or the complaint is not signed. If the complaint is not sufficient, the administrative law judge may allow an amendment to the complaint. This timeline starts over when the amendment is resubmitted. The resolution meeting is an informal process that is held prior to the due process hearing. The resolution meeting provides the parent and the school district another opportunity to discuss the complaint and to attempt to reach a resolution of the dispute without going to hearing. The school district will contact the parent to schedule the resolution meeting. The meeting is held within 15 calendar days of the district receiving the parent's due process complaint and is completed within 30 calendar days. The resolution meeting includes relevant members of the IEP team who have specific knowledge of the facts identified in the due process complaint. Parent and district each determine who is considered a relevant IEP team member. This meeting also includes a representative of the school district who has decision-making authority. The resolution meeting may not include an attorney for the school district unless an attorney accompanies the parent. A resolution meeting is always required except when the parent and school district agree in writing to waive the resolution meeting and move forward with the hearing process, or the parent and school district agree in writing to waive the resolution meeting and use mediation. The resolution meeting is not required if the due process complaint is initiated by the school district. If a parent does not participate in the resolution meeting but the district wants to, the district can ask for the complaint to be dismissed. If the parent wants the resolution meeting but the district won't participate in it, the hearing can start sooner. I've talked about filing a due process complaint and options available to resolve the dispute without going to hearing. If the issue still cannot be resolved, a due process hearing is the next step. This is a special education administrative hearing governed by the Individuals with Disabilities Education Act and Michigan Administrative Rules for Special Education. As mentioned earlier, this hearing process is specifically related to the issues of identification, evaluation, educational placement of a student with a disability, the provision of FAPE, or the appeal of the district's manifestation determination review decision relating to discipline and placement. The due process hearing is formal and the most adversarial process to resolve a dispute. There are many parties and participants involved in the hearing process. Michigan Office of Administrative Hearings and Rules, an administrative law judge who is a trained impartial hearing officer and acts as a judge, parents, attorneys, district administrators and staff, witnesses and expert witnesses, and a recorder who takes notes and a record of the hearing. The administrative law judge is appointed by the Michigan Office of Administrative Hearings and Rules and conducts the hearing and decides the case. A due process hearing is usually conducted in a building in the school district but can be held in another location if agreed to by both parties. The administrative law judge administers oaths, signs and issues subpoenas, and provides for taking of testimony. Prior to the hearing, the ALJ may require a pre-conference hearing if appropriate to determine the areas of dispute and go over the issues, ensure that the matters are clearly defined, schedule the dates for the due process hearing, schedule timelines for providing written arguments called briefs, and schedule timelines for the exchange of proposed written documents and evidence. During the hearing, the ALJ controls the conduct of the parties in the hearing and can grant specific extensions of time and issues a final decision in order. During the hearing, witnesses testify under oath and can be cross-examined. Evidence and exhibits are submitted. There may be objections to testimony and/or evidence and/or documents. There are opening and closing arguments, and the hearing is recorded. The school district is represented by an attorney. Parents can be represented by an attorney, but it's not required. The hearing can take a couple of hours, days, weeks, or months. The due process hearing must be completed and the decision and order mailed within 45 calendar days after the 30-day resolution period. The administrative law judge can grant an extension at the request of either party for good cause, and that's where the hearing can take longer. After the hearing, the administrative law judge issues the final decision and order, which may contain procedural history, the date the complaint was filed, dates of correspondence and hearing dates, the witness list, the individuals who testified at the hearing, exhibit list that could be student transcripts, student attendance records, or IEPs, the issue and dispute between the parent and the district that the ALJ addressed in the hearing, applicable law, which will identify the relevant IDEA regulations and MARS rules, findings of fact, which are facts based on the information presented. This can be documents, testimony, and admitted exhibits. Conclusions of law. This is applying the regulations, rules, and case law to the particular facts of the case and provides a summary of conclusions. The order, which is the decision based on all the above information, and then information about how to appeal the decision. After the final decision and order are issued, if the district prevails, there is no further administrative action. If the parent prevails, the ALJ makes a decision about the appropriate resolution. The decision and order contains a list of things the district must do called corrective action. For example, it could be changing a student's placement, changing a student's eligibility, conducting a new IEP, providing additional services, or providing compensatory services for the student. MDEOS implements and monitors the completion of the order. The appeal of the decision and order is not an administrative process. It is a civil process through a civil court. Special education issues related to the IDEA have to go through a due process hearing before going to civil court. Appeal of decision and order must be done within 90 days. The district and/or the parent can appeal the hearing decision. The civil court process can take 1 to 3 years or more to work through the levels of appeal, from the federal court to the Federal Court of Appeals. An expedited due process hearing is used to appeal a district's manifestation determination review decision related to discipline and placement. This is the only reason stated in IDEA for which an expedited due process hearing can be requested. An expedited due process hearing is the same as a standard due process hearing except for the timelines. The complaint must clearly state that an expedited due process complaint is being filed. The complainant can request an expedited due process hearing, but ultimately the ALJ will decide whether it's expedited or not. The timelines are different for an expedited due process hearing. Resolution period must start within 7 calendar days of the expedited due process complaint being received and must be completed within 15 calendar days. The hearing must be completed within 20 school days, and the decision and order must be mailed within 10 school days after the hearing ends. The resolution period, the hearing, and the decision timelines cannot be extended in an expedited due process hearing. If you're filing a due process complaint regarding a disagreement with a placement change or an appeal to a manifestation determination review decision, the student must stay put in current placement pending the results of the hearing unless the parent and school agree on a different placement. I'm going to wrap up with a snapshot of the quick guide to special education dispute resolution processes from the Center for Appropriate Dispute Resolution in Special Education. This screenshot is a multicolored comparison chart that lists dispute resolution options that I discussed across the top and information about each option process down the left side. This chart is in the resources information at the end of the video and provides a nice summary of how the processes differ, what issues and when they're used, who initiates the process, the outcome or desired result, process distinctions, the benefits and considerations for each process, who the decision maker is in each process, the role of the third party, the time frame, the financial cost, and the impact on relationships and how to prepare. These next 2 slides are resources relating to the topic in the video today. Our comprehensive website includes up-to-date information and resources about special education and disability-specific topics, links to our on-demand webinars and YouTube videos, and information about how you can sign up for our monthly e-newsletter. We share information on social media and offer statewide virtual events and learning opportunities throughout the year. Our materials and events are always free to parents, caregivers, and educators. Michigan Alliance for Families' greatest asset is our regional parent mentors and information referral staff around the state who are here and ready to help you. Regional parent mentors provide individualized assistance and are available to talk to parents and professionals about special education and related services. Find your regional parent mentor on our website by going to the About Us tab or by calling 800-552-4821. When you call this number, you will be sent directly to the regional parent mentor in your area. Thank you again for joining me today.